Welcome to the Three Questions webcast series. I'm Wayne Baxter, Senior Executive Manager with One Capital Management. On this edition of the Three Questions webcast, we're going to ask you the three questions you should ask before establishing an estate plan in Arizona. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions webcast, please consider liking this video and subscribing to our YouTube channel. Now, my clients are often referred to as cross-border clients. Now, why is that? Well, it's because they're either U.S. or Canadian residents who invest in U.S. and or Canadian dollar denominated securities like stocks, bonds, and ETFs. At One Capital Management, we develop and implement strategies that strive for our clients to grow, protect, and ultimately distribute their wealth, and we do that by offering investment wealth management services. Our process for advising our clients includes an in-depth discovery and diagnostic analysis of their wealth management goals and objectives, and as one would expect, that analysis will include a review of their estate planning strategy. Now, on this episode of the webcast, we're going to take a closer look at what makes estate planning in Arizona unique. On this edition of the webcast, we're going to be asking the three questions you should ask before establishing an estate plan in Arizona. Joining me is Heather Parker. She's an estate planning attorney and founder of the Parker Law Office in Mesa, Arizona. Heather, great to see you. Thank you for making time to join us today.
Absolutely. Thanks for having me. I appreciate it.
Yeah. Well, my goal is to, this is the thing that I realized moving from Canada to the U.S. is that estate plans in each state in America seem to be rather unique. They have their own sort of characteristics, and I was really excited to have an opportunity to talk with you and learn more about estate planning in Arizona and what makes it unique. And what really, before we get to the three questions, what really I wanted to touch on was a point that you made that when we were chatting in advance of the webcast, is that when it comes to preparing an estate plan in Arizona, you should really hire an experienced estate planning attorney instead of a general. That's the point that you were making. Avoid hiring a generalist, or worse still, avoid taking the quote unquote do-it-yourself route. I would really appreciate it, and I'm sure our audience would too, if you could sort of expand upon the rationale behind that observation that you made during our earlier discussion.
Well, absolutely. I mean, I think it's like anything else, right? We need specific guidance to our specific situation. And it is estate planning, like many other things, is not a one-size-fits-all situation. There's a lot of extraneous information that the average person wouldn't think matters when you're doing planning that absolutely can matter. It's, things like, I have a blended family. Well, gosh, I treat my stepchildren the same as I do my own, and that's great. And you certainly can in your planning, but it has a very different impact when we're doing estate planning. We have to specifically identify those things and be clear about what potential pitfalls there are if of the couple that's planning, assuming it is a couple, if the spouse that passes first is not the parent of those children, we can have a whole lot of fallout going on unless we plan properly.
One of the reasons I invited you, Heather, to join me was that what I've discovered, and again, I mentioned a little bit earlier, is that estate planning laws in Arizona have some rather unique features. I know we chatted about some of them when we were getting ready to do our webcast here, but some of these features, I guess you'll call them, distinguishing themselves from other states, and some of them can be really useful and others not so much. So in this edition, we're going to assume that we have to also consider the fact that Arizona is a community property state, like here in California, right?
Yeah.
And so it maybe just before we get into the questions, maybe you could maybe just sort of expand a little bit for the audience who've never really understand the context of community property state. If you could maybe just give us a high level explanation of what that means.
Sure. So, I mean, I think one of the easiest way to think about it is it's a sort of the kid approach. It's a what's mine is mine, what's yours is mine state, right? So rather than what we own together being half mine and half yours necessarily, it's all of ours, it's all of mine and it's all of yours, right? It may not seem like a huge distinction, but it is absolutely a distinction, particularly when we're looking at estate planning. Oftentimes in community property states, and there's only 9 of them, we will typically do a joint plan. So if we're looking at specifically trust planning, which is becoming the vast majority of folks, that can be done as a joint trust. In separate property states, that's not the case. Each spouse is going to have their own trust typically. That's not to say that you can't do separate trusts in community property states, but it's usually with specific purposes in mind.
All right, so let's get to the 3 questions you should ask before establishing a estate plan in Arizona. And for this episode, we're going to address our questions from the perspective of somebody who already has an estate plan in place and are relocating, maybe be relocating from Canada, or they may be relocating from another part of the United States, another part. So, okay, the questions are going to be geared from the context of somebody who's already got themselves set up with an estate plan. So, question number 1 is, what changes are required to make my existing estate plan compliant with Arizona estate planning laws?
Sure. So step 1 in all of this, as you were mentioning, if somebody is coming from another country, there can be a variety of different considerations as to whether or not the parties are actual U.S. citizens or if they are citizens of other countries. And that's a whole different context and probably a whole different conversation.
And we could do a whole webcast just on that on itself. Okay.
So for now, we'll just assume that the parties are U.S. citizens and that they have a plan that's from another state in the country. Okay. And I think the initial approach on this is, by and large, when we're speaking about estate planning, if it was valid in the state it was created in, it is theoretically supposed to be valid in any other state. Simply by virtue of the fact that I've moved to another state doesn't make it invalid. Okay. So I think that's important to start with. So I think there's 2 approaches to this. We have to look at things from a legal perspective, which is essentially what we've just done, is say it should theoretically be legal. The second part is more practical in nature. And that is, if I've got a plan that has been drafted and directed to be administered under the laws of a state that I'm not in anymore, it makes it more complicated when we're actually trying to make use of it if the people who created the plan become incapacitated or pass away. So if I'm sitting here in Arizona with a plan that was drafted in Wisconsin, and it says when I die, it's to be administered under the laws of the state of Wisconsin, now you're going to have some practical potential issues, because if you're trying to find an attorney here in Arizona, they don't know Wisconsin law for the most part, in case you happen to roll upon the unicorn that's licensed in both Arizona and Wisconsin, which I mean is theoretically possible. That's actually where I'm from, but that's not going to be the norm. It makes it a little more complicated. It's also going to be potentially an issue based upon what we were talking about a minute ago. If I've come from a state that is separate property and now I'm in a community property state, now we can have some issues, because the way that the plan is going to direct assets could be affected by how we actually hold them before the plan is being used, right? So the presumption in a community property state typically is that if a spouses are owning assets together in a community property state, that they're being held as community property. There's some built-in rules and laws that come with holding an asset in that way that could be counter to what the plan says. So if it's not reanalyzed after coming from a state that might be different, then you could have some problems later on.
So it would not, even though it's in theory possible to basically continue using the original plan, there could be a lot of pragmatic reasons for starting over.
Yes, and not even necessarily starting over. It may just be that you need to make some adjustments to it, right? Okay. It may not be a situation where you have to necessarily scrap it all and begin again. I mean, it's possible you might have to need to do that too. It just depends on what's going on. And I hate to give you the typical lawyer answer of it depends, but it sort of does. Yeah. Everything is very situational. There's not always a hard and fast rule. And that's why I'll often tell people, I don't mind talking in generalities, but please know that your situation might vary from what we're talking about. And it's really important to talk to somebody specifically about your situation. But
okay, that makes sense. I can appreciate that. Okay, so great answer to question number 1. Question number 2, and some people may say this is rather 101, but maybe not, meaning simplistic, pardon me. But what is the difference between a trust and a will?
I think that sometimes the 101 or simplistic questions are really important, because here's the thing, I do this every day. So obviously this may seem rather basic to me, but to the average person who maybe only deals with their estate plan a couple of times in their life, it's
God
not.
forbid if that's all.
I agreed, but we also know what we see come in. So if
Right.
it's not something that you deal with every day, it's not going to be at the forefront of your knowledge, right?
Mhm.
So I think this is a really important question, and it's one that I get often. So think about a will as a more basic direction. So there's only a couple of things that a will really does. One of which is to designate guardians for minor children. So if we are dealing with somebody who has a minor child, a will is very important because that's where you designate it. It is not designated in a trust. And that might sound funny, but trusts really deal with assets. And as much as we might love our kids, they're not assets. Oftentimes liabilities, but they're not assets. So they're not,
Dependents, definitely.
for sure. And it's not to say that we don't provide for them in trusts potentially, but the will is the place that you designate guardians for minor children.
Mhm.
The other thing a will does is your opportunity to indicate who you want to be in charge of your estate when you're gone. Now in Arizona, we call that term a personal representative. Everybody else in the country, as far as I know, refers to it as an executor. It's the
Yeah.
same job. We just, for whatever reason, have decided to call it something different. So you're going to identify who you want that person to be, who's going to be responsible for distributing your assets. And then the other thing the will does is says, where do I want my assets to go? Which sounds basic, and that's really what it's set up to be. Because the most important thing for people to realize is that a will does not stop a probate case. A trust, alternatively, allows you to create very detailed instructions. So where if I've said in a will, I want my assets to go equally to my kids, great. In Arizona, the threshold for a probate case is assets that exceed $75,000 by and large, which means if I pass away and I have $75,000 worth of assets that were in my name that did not have beneficiaries on them, they need to be directed by my
That's
will.
the key part. The key part being the beneficiaries, right? So in other words, if you have a 401k with $400,000 and you rent an apartment, then you wouldn't need probate. Conversely, if you had,
so long as you actually named the beneficiaries,
assuming yes,
and that they
noted,
survived you,
noted,
Yep.
noted.
But yes, you're absolutely correct.
But on the other hand, if you had a $450,000 condo, which I can't imagine you could find in too many places in Arizona, maybe you could, and 70,000 in a taxable account or in an IRA, you would definitely need to have a trust, or you'd need to have it probated anyway.
Well, yeah, and the thing is that I think sometimes people are under the misconception that if I have a will, I don't have to be concerned about a probate case. And that is probably one of the biggest myths out there. A will has to actually be tendered to the court to be valid.
Right.
So it ultimately for it to be able to be used. And so you're already setting yourself up that if we know we're going to have assets that are going to exceed that threshold, yes, it's important to have a will, but know that that's not going to avoid a probate case. And the important thing on that to note is that means ultimately when that will is being processed and administered, whatever money there is to be distributed is going to be distributed to the beneficiaries as a lump sum.
Mm-hmm.
That's important to remember.
Understood.
Because from an estate planning standpoint, we're looking at not only what do we need to be concerned about for the people making the plan, right? What are their issues and concerns? But what about the issues that might be surrounding the potential beneficiaries? If I name directly, say, my children, I happen to have one child, she's 21, great kid, but I wouldn't want her to get a lump of money in her lap. So the way to get those funds to her may not be to just name her directly in my will. It may not be to name her as a direct beneficiary on an asset, because she's going to get that money as a lump. What if something happens to me next week? I don't care if it's 50 grand. That's a lot of money to a 21-year-old, right?
Yes,
if
it
I am
is.
concerned about how she might spend it, or I want it to be used for specific purposes, I can't really structure that in a will. That's not what it's intended to do. A trust, alternatively, gives me essentially a blank slate. It lets me create lots of detailed instructions. It lets me create a lot of backup plans, the whole what if scenario, right? So if I want to think about, gosh, what if something happens to my daughter before she uses all the money that I've set aside for her? Well, where would I want that to go? Well, if I don't have it structured in a trust, then it's been distributed to her. And now I'm reliant upon whatever plan she may or may not have if something happens to her, that's where the money's going to go. Well, maybe I don't really like that idea, right? So the trust is going to allow me to create that detailed set of instructions that says, I want my money to go to my daughter. I want it to be used for her benefit through her college education. I would like some to be earmarked toward the down payment for the purchase of the primary residence. And then maybe I'm comfortable when she's 30 getting access to the rest or some or whatever it is I've decided. Mm-hmm. And then I would have provisions that say things like, if she's gone before all the money is used, I'd like it to go down to the benefit of my grandchildren, if there are any. If there aren't, then maybe I'd like it to go to my sister and I'd like it to be used for this. I can create all those backup plans. It also allows me to create some scenarios for the what ifs that a will doesn't let me do. There's a lot of potential pitfalls, things that can happen in the lives of our beneficiaries that affect how they are going to get their money or how they are going to be impacted by that. So for instance, let's say my daughter suffers some kind of a catastrophic accident and now she is getting some kind of disability benefits from the government. If I've simply named her as a beneficiary on whether it's a direct asset or through my will, she is almost guaranteed to lose those benefits, because benefits like that typically come with a restriction on what other income that person is allowed to receive before they are disqualified. That's something most people don't think about. In a trust, if it's drafted well, there's going to be a provision that says, if at any point when this trust is being administered, one of my beneficiaries is in that situation, now I'm going to create provisions that say my trustee is allowed to do something different. That's just not structured in a will. That's not what that document is set up to do. A trust, on the other hand, can absolutely do that. What if, heaven forbid, my daughter goes down a bad path and she is now suffering from some kind of an addiction issue? Well, if I've simply named her as a beneficiary, she's going to get a lump of cash, which in a situation like that might unfortunately send her down a rabbit hole. And I can set up provisions in a trust that say, hey, trustee, if any of my beneficiaries are experiencing any of these issues, I don't want you to give them the cash. I want you to earmark it for them, use it for rehab if they're ready to go, help with medical expenses, those kinds of things, but don't give cash to somebody who's going to use it for something self-destructive. I can't structure things like that in a will. That's not what it's built to do. But that's exactly the kinds of things that a trust can do. The other side benefit on a trust is the way that it works. So creating all these instructions, how do I get my assets to follow those instructions? Well, I actually retitle the assets once the trust is done. So my house and my bank accounts and my investment accounts, set aside retirement accounts for the moment, but those basic assets all get retitled. So instead of them being in my individual name, they will be in, the Parker Family Trust, or whatever I decide to call it. Exactly. And so now we've got a side benefit to that, because in our analysis earlier about being concerned about a probate case, now when I pass away, I don't have to worry about that $75,000 in assets triggering a probate case, because I don't have $75,000 worth of assets in my name. It's all in the name of my trust now. So now I don't have to worry about that either. So you've got sort of that additional benefit in going that route. And, there's so much more to it, but that's really kind of the nuts and bolts difference.
You brought up something that actually I was going to bring up, and you beat me to it.
Sorry.
No. You're 100% good. I'm noted for going off the beaten trail here, and you brought something up about, a disabled child. So, in California, well, I know for us, we have a special needs trust built into our family trust for one of our children, who we'll say is very high functioning, but nevertheless deemed to be somewhat disabled. So in that, and for the exact reasons that you stated, that, as I recall, I think anything above and beyond $2,000 a year of income you'd be disqualified from any state or federal benefits that you're entitled to. Anything that is bequeathed to that particular member of the family would go into the special needs trust and would be administered by a trustee from there. And that's inside and that's in California, I'm recognizing here, but it sounds very, very similar to what you were describing for Arizona.
Certainly. And so, I mean, one of the things that I'm getting at is if I already know that I have an intended beneficiary that's in that situation, then yes, we would structure essentially a built-in special needs trust for that specific beneficiary. In addition to that, what I will do when I'm drafting, as many other professionals will do, is build in a general provision that says, if any of my beneficiaries end up in that situation, maybe they're not in that position today, but between now when I'm creating this trust and when I'm gone, that occurs. What if I'm not in a position to make a change to my trust at that point?
Mm-hmm.
What if that happens to one of my beneficiaries at a time that I'm already incapacitated? So if I've built in this provision already that says, look, if at any point after this, one of my beneficiaries becomes in that situation where they are getting those benefits, I am authorizing my trustee to now create that special needs trust. That's in essence what I would include in any trust I do, because you never know when something like that's going to happen. And to have that in there, you can really save that beneficiary a lot of headaches later.
Excellent. Well, if there's a lot of confusion between what is the difference between a will and a trust, I think we can compound that confusion, if you will, in the next question. And hopefully, which is, yeah. So the third, so like, well done. I really loved your answer and the detail you went into, Heather. So for the third question, we're going to ask now, this is 3 questions you would ask before establishing an estate plan in the state of Arizona. The third question is, what kind of powers of attorney do I need? And I could, this is there's a lot of confusion over not just the types of powers of attorney that are required, but when they become enacted. So Heather, I'm going to turn that over to you.
Sure. So think about it from kind of a general standpoint. There is a medical power of attorney and then a financial power of attorney. Mm-hmm. And I think I'll tackle the medical one first. Okay. Arizona has a separate mental health care power of attorney statute. So we may make it a separate document, we may combine it, but know that a healthcare power of attorney and mental health care power of attorney are sort of 2 separate animals here, and they are addressed separately. So the concept of the medical power of attorney is your opportunity to identify who you want to be able to make medical decisions for you if there's a time that you can't make them for yourself. Mm-hmm. So that's really important because none of us really knows when something might happen where we're not capable of making a decision and there's one that needs to be made. So having established ahead of time who those people are that you would trust to make the decisions that you would want made is really important. Because if you don't, it opens the door for discussion/argument among family members. And, you know, I think everybody likes to think, oh, my family would never do that. You know what? You might be right. However, I would challenge you to consider the last time your family tried to go out for dinner and wanted to pick a restaurant. And now let's think about real serious things, right? So I don't know that I think we like to think that everybody would all get along, and it certainly isn't necessarily because they don't all love you and want to take care of you, but people come with different ideas to the table. And 100%. So it's really important for you to be clear on who you want to do things for you so that there is no room for discussion. It doesn't mean that they can't talk to them, right? If I've got, 2 siblings and I choose to have my brother be my medical power of attorney, doesn't mean he can't talk to my sister. It's just he's the one who's actually authorized to make the decision. Mm-hmm. And that's because I felt that he would make the decisions that I would want made. So it's really important to think clearly about who you choose to serve in those roles and not necessarily the knee-jerk reaction, which I think, particularly when I'm dealing with parents who have more than one adult child, they think they'll just go in birth order, which may or may not make sense. We've got to really think about people's skill sets and, whether or not they're really the best choice. They might be a great kid, but maybe that's really not where they're going to be successful. So that's important. So the medical side, like I said, in Arizona, we've got not only the healthcare power of attorney, but the mental healthcare power of attorney is separate. We've got to be clear who we are authorizing to make those kinds of decisions as well. So we could be talking about psychological disorders, substance abuse. We're also potentially talking about memory care issues. And
That was the one I was going to bring up actually, was does this fall under the cognitive, as the odds are, when you get into even as early as in your 60s, but definitely 70s and 80s for sure. One of the activity, one of the non-physical issues that people have before they go into long-term care could be the loss of cognitive ability. So
yep.
so there's a separate provision for that above them outside. Okay, good to know.
Arizona is one of the few states that has a separate statute about that.
Interesting.
So it's really important that that gets addressed. So that's sort of the medical side. The financial power of attorney, you'll hear different terms used for it. General durable power of attorney, it all has to do with the money and the assets. So essentially what a financial power of attorney says is, I'm going to nominate the following person or persons to be able to manage my money and my assets if I am ever incapacitated. Incapacity has a wide range, but in essence, what we're talking about is somebody's inability to manage their own affairs. Could be temporary, could be long-term, does not necessarily, the term incapacity makes people think of somebody who's unconscious. And
Right.
while, yes, that's true, that person is incapacitated, there's other lanes that incapacity could sit in. I might be able to carry on a full conversation, but I may have diminished cognitive ability.
Mm-hmm.
So that I can talk to you about the weather.
Your decision-making abilities may not be as strong as they used to be.
Exactly. I may not understand how to add numbers. I may not understand how to pay a bill. There can be a wide variety of things. It could be physical. Maybe I just can't get to the bank. Maybe I have my cognitive function, but I'm not able to manage things. And in that situation, there's other things that we could do. But typically the financial power of attorney use is my inability to manage my affairs. And
right.
Here's the trick to that, though. And I don't know that this is necessarily restricted to Arizona. There's a wide range of financial institutions that will not accept an outside financial power of attorney. So, and when I say outside, I mean one prepared outside of that institution. That is something we've seen a huge influx of, especially over the last few years. So if I walk into a bank and I bring in a power of attorney that my attorney prepared, the bank has the right to look at it and say, we won't accept that.
Interesting.
We have our own policies and it doesn't meet our policies, the guidelines. So what you're finding is a lot of these institutions may have the ability for you to designate a power of attorney directly with them, but that will be specific only to the accounts that they hold, which would mean you're going to have a conversation with each institution that you hold accounts with, whether that's a bank account, whether it's
but they would
a
be notified
account.
of that.
No. Nope. The banks don't tell anybody. Here's the thing, because when you open a bank account somewhere, there's obviously paperwork to be filled out, right? There's lots of fine print and no one reads it and they sign it and say, I want my bank account open. Well, somewhere in that fine print, it says something along the lines of, you agree to abide by the policies of the bank, which we can change anytime we like and not tell you, and often will. So, I mean, not in those words, but that's the gist, right? They have the right to change their policies and they don't necessarily have to tell you. The unfortunate part about that is we tend to find out these things when someone's actually trying to do something for us. It isn't until the sister presents the power of attorney and says, my sister's in the hospital and I need to help, that the bank will say, sorry, we won't take that. So it's really important that people find out before it's needed what your bank will or will not take, and make sure that you've jumped through the appropriate hoops so that if something like that happens, you've set that groundwork already for somebody to be able to step in.
I knew that you would be triggering a bunch of questions for me here that, and you have. So I got a what if scenario to run by you here. I'd like to hear how it would be dealt with. So let's say we have a situation where, I think I'm probably going to I'm going to show my age here, but we're going to assume that maybe the father, the grandfather is the patriarch of the finances. Mom has basically delegated that role to him. Yep. And dad no longer, he's still alive and functioning to some degree, but he's clearly doesn't have the ability to, pay the bills anymore. and maybe make it to the bank to make deposits, et cetera, et cetera. Still alive, still cognitively somewhat still okay. And it's recognized by, say, one of the children that this is an issue. How, they go to the bank on their own and say, dad just isn't up to it anymore, they're going to say, yeah. Or if they come to a financial planning firm like ours and say, dad's not doing great, I'd really like to take it over. I mean, how does that, what are the next steps what are the legal next steps that are required to take this power of attorney that's been put in place? And maybe he has named this a son or daughter to be the power of attorney. They are legitimately the right person to be doing that role. Who gets to, basically, for lack of a better word, Heather, pull the trigger on that power of attorney? Is it the attorney? Is it what has to happen?
And I love questions like this because this is the practical approach to planning, right?
Right.
I can create a plan, but how does it function, right?
Right.
Logistically, how does it work? And I'm going to give you my favorite lawyer answer, which is it depends.
I knew you were going to.
Because the reason it depends is that the terms of the document itself direct how we get there. It's going to tell us what the hurdle is. So it's entirely possible that the power of attorney will say, determination of incapacity is based on the statement of my personal physician. It might say it requires the statement of 2 independent physicians. It might say, there's also the option for a financial power of attorney that is what we call immediate. So if I could theoretically sign a financial power of attorney that says my sister is authorized to access my accounts as of today, not necessarily wait until I'm incapacitated. That causes people sometimes some pause, and I understand that. But the one that we've been talking about up till now is oftentimes referred to as a springing power of attorney, meaning that ability for that person to step in only springs into action when I am incapacitated. And so, like I said, the document itself is going to direct what is going to trigger the spring, right? What is going to have to happen to allow this named person to truly step into that role? And it is almost always going to involve a physician statement. In almost everything that I have seen, it is typically going to be that, which can make things a little awkward, right? We've got to be able to be comfortable having those conversations in and among our family. The difficulty is oftentimes when people are starting to decline in their abilities, they don't like to recognize it. That's right, a difficult, 100%. That's a horrible position to be in, to feel like you are losing the ability to manage your own assets.
Right. It's a part of being independent, right? Your own dignity.
Which is why I'll often counsel clients to consider adding their trusted people on before we get to that point. So depending on what the planning looks like, if we're dealing with a trust, then I will say, we might want to talk about adding a co-trustee so that transition is a lot easier, because that person that we've chosen, whether it's an adult child or a sibling or whoever it's going to be, is already on board before I get to that point. So we don't truly have to wait until I am fully incapacitated and battling to figure out how am I going to get a doctor's note to be able to step in and help.
Right. Okay, I realize that we're burrowing a nice deep rabbit hole here, but I'm going to ask, I got a couple more. Okay, so let's say this particular case, I'm doing what if scenarios, are just throwing me into the it depends mixer here. But if the patriarch here in this example I've conjured up were to simply call his bank and say, you know what, I want my daughter or son who's listed as the power of attorney to take that role on, effective immediately, is that acceptable, or will still a medical opinion be required based on your experience?
Depends on what the document says.
There you go.
So I will tell you, when I'm drafting a financial power of attorney, I always have an option that allows for the person who's creating the power of attorney to have an additional page that they can sign to make that power effective immediately. So usually I'm drafting a springing power of attorney that, only comes into play once I'm actually incapacitated, but then there's an option so that I can sign giving immediate authorization in case something's coming up. I'm going in for serious surgery and it's going to be a long recovery. Now, theoretically, in the situation like that, they would be able to get a doctor to say, yes, she's not going to be capable of doing things, but that's another hoop to jump through. If I can authorize this person to access simply by signing this and getting it notarized before I even have the surgery done, that's a whole lot easier. So it's not always a matter of what is legally allowed. It's a matter of what practically is going to be easier.
Okay, before we wrap up here and set you free, Heather, I'd like to get your opinion on the selection process for choosing a power of attorney or trustee if you don't have strong to the U.S. As you know, I work with a lot of cross-border families, and as I'm sure you're aware, choosing a non-U.S. resident to be a trustee that can cause a whole bunch of tax headaches that we don't have time to get into today. But for example, here in California, clients can choose a private fiduciary. And I was wondering if that is an option in Arizona. Is that something that if they came to you and said, you know what, I don't have any close family ties here. I need an Arizona-based trustee, or I'd like to have one. Can I hire a fiduciary basically on a private basis? Does that work for Arizona residents?
Absolutely. Yes, we've got lots of great fiduciaries here, and that is a recommendation I often make. Not necessarily just because somebody doesn't have anyone close to them.
Yeah,
but there can be a wide variety of reasons why we don't want to put a family member in that position. Yes.
You just actually, one last point before we wrap up here. If I've had a change in opinion over the last, say, the 11 years since I moved here to the United States, is the role of financial power of attorneys. And I'm becoming more and more and more convinced as the days and weeks and months go by that almost from the default, if you could hire a professional fiduciary to take on the role of financial power of attorney, I would recommend it. That's, again, I know I'm making an opinion here, but from the constant, and I know you being an estate planning attorney, you probably see way more of this than I do, but the constant stories of, families with multiple siblings, and they all come from different sort of stations in life, and what goes on with the finances of the family sometimes can be really out of line, I guess would be the way.
Absolutely. And I would say the vast majority of times when we're talking about this, it's putting a fiduciary in the trustee role, because the vast majority of assets are being held by the trust anyway.
Yeah.
But it can be so helpful. And sometimes I'll get pushback from folks saying, well, I don't want to have to pay somebody. Well, number one, anybody who serves as trustee of your trust under statute in Arizona is entitled to be paid for their time.
Right.
So that's number one. Number two is think about, and part of this I think comes because most people don't realize what's involved in actually administering an estate plan, or worse even a probate case. But because there's so much that needs to be done, it's like anything else. If I put a professional in that role, they're going to be a lot more efficient at getting these things done because they're used to doing it. They do it all day long. So I'm actually potentially saving myself money in the amount I'm going to pay a professional versus what I'd have to pay the lay person who is not familiar with all of this to still have to get it all done. So I often will encourage clients to consider it, and seriously consider it, so that they can take that role out of the hands of their loved ones and let their loved ones just grieve and not feel like they've got to wade through all the things that need to be done on top of it.
Right. And try to minimize controversy.
Well, that's just it. Because imagine, even just a family with a couple of kids, you're going to put one child in charge of when the other one gets their money. That's a surefire way to reap havoc in the family. Not to mention if we've got a blended family, now you've got even, more potential chaos going on. Sometimes it's just better to say, we're going to take this and let a third party deal with it. You all might not like what happens, but you're not going to yell at each other. You can say you don't like the trustee, and it doesn't matter because they don't care. They're just following the instructions.
And again, kind of the motivation here is to leave a legacy of harmony as opposed to lifelong acrimony.
Yeah. Well, and how many times do you hear stories about people who say the family was broken after so-and-so passed?
100%. And it doesn't take that much. I can tell you a personal family experience. It does not take 6, 7, 8 figure lump sums of net worth to create a firestorm between siblings. I've seen it with my own eyes. So
Yep, many times it has nothing to do with the money. Sometimes it's a
it
sentimental
has to
thing.
do with history, and the
Yep.
money just brings it all back to the surface.
Absolutely.
100%. All right, Heather, you've been great today. I really enjoyed having you as a guest, and I hope
Thank
we
you.
can
It's
have
my
you come back
pleasure.
again. This was awesome. For someone who's looking to get a hold of you, they're looking for your help. What is the best way for them to reach you? How can they contact you and probably get a
Sure.
hold of you?
So my phone number is 480-264-5177. I have a website. It's parkerlawaz.com. They can contact us in both of those ways.
All right. Well, listen, again, Heather, thank you very much. Heather Parker
My
is an
pleasure.
estate planning attorney and founder of the Parker Law Office in Mesa, Arizona. Heather, thank you, and we'll see you soon.
Thanks so much.
I look forward to bringing you the 3 Questions webcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube channel. And to receive notification of when our latest webcast has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and see you soon.